Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncement and also to navigate through the intricacies of the insolvency proceedings. So let us discuss one very important real estate case today. Now, this is the case of New Okhla Industrial Development Authority versus Anand Sonbhadra. It was decided on 17th of May 2022 by the Honorable Supreme Court of India. So now this case of New Okhla Industrial Development Authority, which is Noida, versus Anand Sonbhadra, wherein the Honorable Supreme Court declared that Noida is an operational creditor and not a financial creditor for the purposes of a CIRP under the IBC 2016. The pronouncement comes in relation to real estate companies undergoing CIRP, where Noida had provided land under lease deed, and outstanding dues of lease premium under the lease deed were claimed by Noida as financial debt. The claim of Noida was based on two grounds. One, that the lease deed was a finance lease, as per the Indian accounting standards, and alternatively, the lease deed entailed a transaction having the commercial effect of borrowing. Now, let us see what are the facts of the case. The corporate debtor and Noida entered into a lease deed to build residential flats that Noida had approved. The lease deed stipulated that 10% of the consideration was paid upfront and the remaining 90% was to be paid over 16 half-yearly installments, plus interest that accrued during the moratorium period that the lease deed specified. Noida initially filed Form B as an operational creditor for outstanding dues against the lease of plot granted in favor of the CD. Later, Noida filed a claim in Form C, seeking the status of Noida to be recognized as a financial creditor. Thus, the main issue which arose before the NCLT, the NCLAT, and the Honorable Supreme Court was whether Noida is entitled to be treated as a financial creditor under the code. Now, a financial creditor is defined under Section 5, subsection 7 of the Code as any person to whom a financial debt is owed. Hence, it is paramount for Noida to prove that the lease deed entered between Noida as a lessor and the CD as a lessee falls under the definition of a financial debt. Section 5, subsection 8 of the Code defines financial debt as a debt along with the interest that is disbursed against the consideration for the time value of money. Thus, prima facie, there are two significant limbs. First, the presence of a financial debt, and second, this debt has been disbursed to the corporate debtor. Now, let us see the classification of Noida. Now, Ind AS 17 defines a financial lease as a lease that transfers substantially all the risks and rewards incidental to ownership of an asset. Title may or may not eventually be transferred. Therefore, the conditions for a lease to be a financial lease are A, it transfers all risks and rewards incidental to ownership, and B, the lease must be classified as financial or capital by the lessor since the lease's inception date, which is the date of the agreement or date of commitment by parties, whichever is earlier. Now, to see the analysis of the risks and rewards criteria, the transfer of risks indicates considering all possibilities of a loss, such as a change in the economic conditions, technological obsolescence, and cessation of operations, while reward means profit and economic benefits generated from the lease. While it is paramount to prove this transfer of risks and rewards, it must be a transfer incidental to the ownership of the asset, which means the transfer of the control of the asset. Now, two axes support Noida's contention that there is a transfer of risks and rewards. Firstly, the lessee can fix the price for the dwelling units and is free to appropriate the profits. Secondly, since the lessee was given the authority to transfer the flats, the ownership of the land has been transferred to the lessee. Now, let us see what are the observations of the court. The court observed the following. Firstly, profits generated from commercial activities by selling units by the lessee could not be considered a reward incidental to ownership. Secondly, there is no sale of land in the present case, as it is a lease by which almost all the rights are controlled by the lessor, that is Noida. The appellant argued that the underlying asset in this lease deed is the residential flats to be sold along with the land. However, the court observed that the underlying asset is the plot of land and not the residential flats to be constructed. As the lessee constructs the residential flats in the present case, which it will sell to the home buyers, the title will flow directly from the lessee to the sublessee and not to Noida. Further, the court noted an absence of an ownership transfer clause in the lease deed. Thus, the current lease does not give the title to the appellant, and the title is the primary ingredient to prove ownership. Additionally, since ownership did not belong to the appellant, naturally substantial risks and rewards were not attached to Noida, but to the corporate debtor, which is the lessee and the sublessees. Hence, the Honorable Supreme Court concluded that Noida did not satisfy the criteria of transfer of all the risks and rewards incidental to ownership of an underlying asset, as these risks and rewards must stem directly from the rights of ownership and not the rights of the lessee. Also, in the present case, Noida had not classified the lease as a financial lease from its inception, as also the lease was not recognized as a financial lease on Noida's balance sheet as prescribed under the Ind AS 70. Additionally, there was no disbursement of money in the present case from Noida to the corporate debtor. The court observed that a disbursement is a prerequisite to satisfy Section 5, subsection 8d of the Code, and that it should flow from the creditor to the debtor. While Noida did not meet the requirements under Section 5, subsection 8d, it sought further protection under Section 5, subsection 8f of the Code, stating that the current lease is a financial transaction falling under Section 2, subsection 33 of the Code. Now, does Noida's lease fall under Section 5, subsection 8f of the Code? Section 5, subsection 8 of the Code states that any amount raised under any other transaction, including any forward sale or purchase agreement, having the commercial effect of a borrowing, is a financial debt under the Code. Under Section 5, subsection 8 of the Code, Noida put forth its argument that a disbursement is not always a requirement, and that a lessee, such as the one in the present case, is raising funds under the lease deed, and therefore it falls under Section 5, subsection 8f, even though there is no actual disbursement. Noida contended that the lease in question acts as a tool of financing and is a mode of upfront payment to the lessee, even if there is no actual disbursement of money from the lessor to the lessee. Noida supported its argument by relying on the Pioneer Urban Land and Infrastructure Limited versus Union of India, wherein the home buyers were considered financial creditors on the payment of advances and installments in return for the flats. Since the lessee in the present case is obliged to pay the balance of 90% of the lease premium, the appellant draws a comparison with the situation as in the Pioneer case. Therefore, Noida contended that the transfer of funds in this case is the mode of advance payment of 10% of the premium paid by the corporate debtor to the appellant, and the balance of 90% of the lease premium is the amount raised in this transaction, thus falling under Section 5, subsection 8f. Now let us see what are the observations of the Honorable Supreme Court. The Honorable Supreme Court rejected the argument that the advance payment of 10% of the premium paid by the CD to the appellant is the transfer of funds. The Supreme Court held that this advance payment does not represent a substantial amount of the fair value of the asset. Further, there is no disbursement of any money or advances being paid from Noida to the corporate debtor. In the case of home buyers, there is generally an actual transfer of funds to the corporate debtor or the real estate developer. In the absence of any transfer of funds from the creditor to the debtor or in the absence of any advances to the CD, the law laid down in the Pioneer case does not apply. Therefore, Noida was classified as an operational creditor since the lease was not a financial transaction and Noida did not satisfy the conditions mentioned above to be recognized as a financial creditor. Now, let us see what are the implications of the judgment. According to Section 6 of the UP Industrial Area Development Act 1976, the purpose of the Industrial Development Authority shall be to secure the planned development of the industrial development area. A public authority entering into an agreement, such as the lease deed, cannot have a commercial effect of borrowing, as commercial effect would mean to earn profit or that the primary purpose of the deed is profitability. These debts towards the corporate debtor qualify as statutory dues under the code, and therefore they cannot be sought with a motive of seeking a greater value or profit. The motive to earn profit or seek greater value in dues is incompatible with a public authority's duty to secure development, as it is not a commercial entity but a public one. So, friends, we conclude that the judgment provides a much needed relief to stakeholders involved in several real estate projects whose CIRPs have been stalled by authorities like Noida on account of their demand to be classified as a financial creditor. Also, this should be beneficial for home buyers as affected CIRPs would be concluded expeditiously. So, friends, we see here that the Honorable Supreme Court has protected the interests of the home buyers vis-a-vis Noida Authority. So, thank you, friends, for being with me here today. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.